Hello, everyone. I think we will get started. Welcome to the 9th webinar of the Grievance, Redress, and Accountability Mechanism Partnership, the GRAM Partnership. I'm Peter Carlson, the Communications Officer at the Independent Redress Mechanism of the Green Climate Fund. Before we begin, I'd like to remind you of a few administrative matters. First, there's interpretation available. So if you'd like to listen to this in English, Spanish, or French, you can click on the More button at the bottom, then Interpretation, and then you'll be able to toggle between the three languages. While we ask you to mute your microphones during the webinar, we invite you to keep your video on so that you can get to know the other members of the GRAM Partnership. And lastly, the webinar will be recorded, as you can see, and a portion of this will be published online after the webinar. We will, at the end, have a Q&A, which I'll mention in just a moment, and that part will be removed from the public recording, but everything else will be shown publicly online afterwards. Today's webinar is hosted by the Independent Complaint Mechanism of the International Climate Initiative of Germany, also known as IKI ICM. The webinar will focus on worker rights and grievance redress mechanisms, a topic that I think is very interesting for many of us here. And panelists will discuss worker rights in international conventions and international financial institutions, environmental and social standards. They will also explore previous worker complaints filed with independent accountability mechanisms and share CSO experiences in monitoring worker rights abuses, amongst other things. So if we can go to the next slide, I will now introduce the panelists for today's webinar. First, we have Andrea Cont, who heads IKI ICM. She led the process in the establishment of the mechanism since January of 2021. Prior to this, as a senior policy advisor at the Germany Institute for Human Rights, she advised and worked with the German government and development cooperation agencies GIZ and KfW, as well as the European Union, on implementing a human rights-based approach to development. She has over 20 years of experience in human rights, accountability, sustainability, standards, participatory governance, and stakeholder management, working with public, private, and civil society sector organizations. Second, we have Lalana De Silva, who is a member of the independent expert panel of IKI ICM, and he's also the managing director of Transparentum. He was the first head of the Green Climate Fund's independent redress mechanism, and he has extensive experience in legal affairs with more than 40 years of service as a lawyer. In Sri Lanka, he supported the Ministry of Environment as a legal consultant and was a member of the country's law commission. He previously worked at the Environmental Claims Unit of the UN Compensation Commission in Geneva and served as director of the Environmental Democracy Practice at the World Resources Institute in Washington, D.C. As a member of the Compliance Review Panel of the Asian Development Bank, he led the review of multiple compliance cases. Next, we have Jonathan Mead, who is the Director of Investigations at Transparentum. Prior to joining Transparentum, Jonathan worked in the private sector as an environmental geologist with an international engineering and scientific consulting firm, investigating and remediating contaminated land and water resources in North America, the Caribbean, and Oceania. He has volunteered with Engineers Without Borders USA for more than a decade, leading water supply, system assessment, design, and installation projects in India and Cameroon. Next, we have Andrew Corfidge, who is the Director of Strategic Engagement at Transparentum. Prior to joining, he managed external media relations and intra-organizational communications with affiliated apparel, electronics, and agricultural companies for the Fair Labor Association. Previously, Andrew was a writer and editor for Green America, a green economy organization promoting socially and environmentally responsible businesses. And last but not least, we have Radhika Goyal, who's a policy associate at Accountability Council, where she advocates for international finance to be more accountable to the communities they impact. Prior to this role, she was a legal fellow at Migration and Asylum Project, where she worked to strengthen access to justice for migrants and refugees who are at risk of and survivors of sexual and gender-based violence in New Delhi. Now we'll move on to the agenda, so you get a sense of what we will be discussing today. First, Andrea Camp will provide a short introduction as the host of today's webinar. Next, Lalana De Silva will provide some background information to frame the webinar and discuss worker rights and social safeguards of international financial institutions and grievance redress mechanisms. Next, Jonathan Mead and Andrew Kofidge will talk about worker rights in international labor, ILO conventions, investigations into worker rights abuses, and company engagement and remediation. Lastly, Radhika Goyal will share research from the Accountability Council's Accountability Console, looking at worker complaints filed with grievance redress and accountability mechanisms of international financial institutions. She'll also share a case study and discuss remedy. And then at the very end, we will have time for questions from the GRAM members, and then we will close today's webinar. So with that said, I will now pass the floor over to Andrea, who will give a short introduction.
Thank you, Peter. Hello, everybody. My name is Andrea Kempf, and I'm part of the IKI Independent Complaint Mechanism. The IKI is as Peter said, the International Climate Initiative. It's a funding instrument of the German government for climate and biodiversity. And the IKI Independent Complaint Mechanism is, I think, one of the most recent members of the IAM network. We joined last October. And we have some particular features, and allow me to mention them. We cover not only environmental and social safeguards complaints, but also complaints related to the misuse of funds. And we do not require individual personal harm when it comes to serious environmental harm. So that's maybe a little bit specific about us. We also do accept anonymous complaints. I'm really glad to be part of this webinar. I would really, first of all, like to thank the IRM, you as a co-host. Thanks very much for organizing this, and also the speakers for setting this up. I think it's very timely, not just because of the complaints that IFIs have been receiving with, related to labor rights and working conditions, which we will hear about from our speakers, but also because of increased attention, at least coming from a European perspective, on supply chain due diligence. And having said this, violations of labor rights and working conditions do not just happen in projects of big institutions or in large infrastructure projects. Even in a comparatively smaller bilateral climate and biodiversity funding instrument such as IKI, a quick survey of mine among my colleagues unearthed a series of potential risks related to workers. So, for example, the working conditions of local waste collectors in the context of build forward better measures, then the health and safety measures in place for workers who have been constructing concentrated solar power towers, and CSPs, contemporary forms of slavery among local fishermen and projects promoting integrated coastal management, and also other projects to monitor for us in the future might be those concerning the construction of battery storage facilities and hydrogen plants. And while the IKI ICM does not yet have a complaint concerning labor rights or working conditions, I'm really looking forward to learning from the experiences of other mechanisms, and would like to hand over to Lalana.
Thank you, Andrea. Thank you, Peter. Thank you to the Green Climate Fund's Independent Redress Mechanism for co-hosting this with the IKI mechanism. And also thank you to our colleagues from Transparentum and from the Accountability Council for joining and agreeing to be resource persons and speakers for this webinar. I want to start by framing the webinar for all of you and to say that there are in the background, I shall say the foundation of what we're going to talk about, labor rights, the several fundamental labor instruments, if you like, from the International Labour Organization or the ILO. On the slide, you will see a number of them listed, starting with the Freedom of Association and Protection of the Right to Organize Convention, the Right to Organize and Collective Bargaining Convention, both of which have to do with trade union rights, the right to associate, the right to bargain collectively for worker rights and workers' safety and conditions of work, etc., Those are covered by the first two conventions. Then you have the Forced Labor Convention and the protocol to that convention, and also the Abolition of Forced Labor Convention of 1957, all three of which have to do with trying to get rid of forced labor in the workplace. Then you have the Minimum Age Convention, which has to do with employing children and those below the minimum age. We'll discuss that in a minute. And then, of course, the Worst Forms of Child Labor Convention of 1999, both of which deal with children and their right to be free of the conditions that bring them to these labor camps and working conditions in which they are being employed underage. Then you have the Equal Remuneration Convention, which has to do with discrimination with regard to remuneration. You have Discrimination, Employment and Occupation Convention, both of which have to do with discriminatory treatment of workers and their right to equal remuneration. And then you have the last two conventions there, which have to do with safety and the health of workers, the Occupational Safety and Health Convention of 81, and the more recent 2006 Promotional Framework for Occupational Safety and Health Convention. These are all ILO conventions to which governments, the international community consisting of states, as well as employer organizations and employee organizations have all agreed, and therefore forms the foundation of much of what we're going to speak. Next slide, please. There are also two United Nations conventions. One of them is the Convention on the Right of the Child, and then the other one, the UN Convention on the Protection of the Rights of All Migrant Workers and Members of Their Families. Many of these factories and workplaces on the ground, particularly those that are exporting, have migrant workers, the apparel industry, the battery industry, the mining industry. Many of them employ migrant workers, and therefore protecting their rights and ensuring that they are safe at their workplace has become a matter on which the UN has now legislated. And this also is true for the rights of the child. Next slide, please. Now, with regard to the ILO's conventions, there are what we call core labor standards. The first of these, starting on the left-hand upper corner, is the freedom of association and the effective recognition of the right to collective bargaining, the right to form trade unions, the right to negotiate with the employer collectively for your rights. That's the first of the core labor standards, or the core labor rights, if you like. The second one, moving to the right-hand side, is the elimination of all forms of forced or compulsory labor. The third one, of course, has to do with children, the effective abolition of child labor. And then we come to the bottom row from the left again, the elimination of discrimination in respect of employment and occupation. And finally, we come to a safe and healthy working environment for workers. These 5 things constitute what we refer to as core labor rights: the right of association, the right to be from freedom from forced labor, the protection of children from work, anti-discrimination theories and principles, and safety at work. These are the core labor standards. Next slide, please. Now we get to what we call, I want to concentrate a little bit on forced labor, because this is a fairly common problem that you see across the board, particularly with migrant workers. You'll hear from our colleagues on specific examples. And the ILO, the International Labour Organization, has what we called forced labor indicators. If one or more of these indicators are present, you can suspect that there will be likely forced labor present, and you obviously would then have to investigate it more. So starting on the left-hand side, abuse of vulnerability, particularly with migrant workers, children, young people, women, other vulnerable groups. That vulnerability can be abused by employers, and it often does get abused by employers. And so that is an example of an indicator. Deception of the worker as to their conditions. They're told one thing before they are employed, and when they come to work, it is another thing. They're told they'll be paid one thing, they actually come to work and they actually paid something different. And then you have restriction of movement. That is, workers are not allowed to go out. Often you'll find that in some of the fisheries industries here, even in the United States in the South, you will find that people are literally imprisoned on board ships. Their passports are taken away. They cannot get to land, and they're there for years, sometimes on these ships, literally almost like slaves. So that's restriction of movement. Isolation, very often you'll find these workers isolated, separated from everybody else, isolated and kept in hostels, not allowed to go out, etc. That's another element of a forced labor indicator. Physical and sexual violence, particularly against women. Intimidation and threats. You find that supervisors often intimidate and threaten workers with dismissal, with other kinds of pay cuts and so on. If they make mistakes, these are all indicators of forced labor. Retention of identity documents. You'll find that in many countries, particularly in the Middle East, sometimes in Eastern and in East Asia, for example, you'll find that when workers land, their passports are taken away. Their identity documents are taken away so that they cannot move around, they cannot run away, they cannot leave the workplace. Withholding of wages. They're not properly paid, their wages are withheld, and as a result, they then fall into debt. They borrow in order to repay their debts. Very often, these workers have to pay agents in order to get their jobs in their home countries. They fall into debt doing that, and that we call debt bondage. So that's another indicator. Abusive working and living conditions, of course, is enough. And then last of all, excessive overtime. You're allowed to work overtime more than the 8-hour day, but you're not properly paid, or you're asked to work far too long, sometimes 24 hours, 48 hours without a break. These are all indicators of forced labor. We go to our next slide now. I want to deal with the minimum age and child labor in particular. So there is, as I said, the ILO Convention on the minimum age convention, which fixes the minimum age at least at 15 years. So anybody employed below 15 years would be considered a violation of this ILO convention. Now, of course, our convention does make some exceptions. And for example, you'll find exceptions which reduces the age to 14 years, for example, for those who are in the agricultural sector. You might have a child in a family working for a on a family farm, and there you can have some exceptions. Now, 18 years is the minimum age for unsafe work, that is hazardous work. You cannot employ anybody below the age of 18, particularly for unsafe work. And that is true also in the exceptions. You cannot employ somebody for unsafe work for less than 16 years, or in the case of a farm child, for example. Now, this convention, of course, has to be ratified by the country concerned. So you need to look at the country's laws to see what the minimum age has been fixed. It's not enough to look at the ILO conventions. You need to look at the country's laws, and then the country legal definitions are what would generally apply. So if you're working in India and looking at the situation in India versus some other country like Madagascar, you need to look at the laws of those countries with regard to child labor and minimum age. And usually these have to be aligned with these with the ILO convention, but they're not always. So one has to look at the country laws to be clear. Next slide, please. Now, I want to now move from the ILO convention, the UN conventions, to what we find with regard to international financial institutions and their safeguard laws. What do we find with regard to labor and labor rights in them? And I want to take as kind of the, generally treated as a gold standard, the International Finance Corporation, or the IFC's Performance Standard 2. Labor and working conditions. Performance Standard 2 deals with labor rights and labor conditions. And what it says is essentially that to promote the fair treatment, non-discrimination, and equal opportunity of workers, there are 4 things that need to be done in particular. The first, of course, is the relationship between worker and management. And here to establish, maintain, and improve the worker-management relationship. The second one, the purpose of this safeguard or this standard is to promote compliance with the national employment and labor laws. The third is to protect workers, including vulnerable categories of workers such as children, migrant workers, workers engaged by third parties, and workers in the client's supply chain. We'll hear more about that in a little while. And then the last, of course, is to promote safety and healthy working conditions and health at workers, and to avoid the use of forced labor. So these five, if you like, important objectives are what is sought to be done through Performance Standard 2. Next slide, please. Now, this Performance Standard 2 applies to direct workers, that is to say, employees who are full-time employees, who get paid a regular salary, who have a contract of employment. So the standard applies to those. So for example, if an international financial institution like the IFC or the Green Climate Fund or any of these other institutions provides funding for a project, and the project is employing people, full-time staff, then of course Performance Standard 2 and its requirements will apply to them. It also applies to contracted workers, that is, people like contractors, brokers, agents, etc. And what is really important to understand with regard to contracted workers is that these workers may not be directly under the control of the project agency or the project developer for whom the funds have been provided, but they may be employed by third parties, and engage, for example, in the core project work, but in those cases also you will find the Performance Standard 2 applies. And then last but not least are supply chain workers. It applies to supply chain workers, and these are people from whom you are buying material. For example, if an agency were to fund, let's say, a solar farm somewhere, right, in a country, if the solar farm is purchasing solar panels from a supplier who is employing forced labor or child labor, then that could be a violation of Performance Standard 2, because all along that supply chain, one has to look to see whether the conditions of Performance Standard 2 are fulfilled. Now, with regard to direct employees, we can go to our next slide. You will find that the highest protection under Performance Standard 2 is given to these direct employees or full-time employees. You need to have proper human resource policies and procedures in place. You need to have good working conditions in terms of employment. You need to allow workers' organizations the freedom of association and trade unions. You have to be non-discriminatory and provide equal opportunity to your workers. There are special provisions regarding to retrenchment. That is, if you have to let go of a group of these workers, there are conditions and procedures that need to be followed. You need to have a grievance redress mechanism in place under Performance Standard 2, dealing particularly with worker rights. You cannot have child labor and you cannot have forced labor at your work site. And you need to ensure that there's occupational health and safety. So all of these safeguards apply to direct workers under Performance Standard 2. Next slide. When it comes to contracted workers, all of those previous rights apply except for the provisions regarding retrenchment. So you can see a deleted retrenchment there. And your grievance redress mechanism, if the project does not have, or the project organization does not have one or has one, you have to extend that to include contracted workers. So that is very important. The grievance mechanism must not only apply to your own employees, but also to contracted workers. So those are the safeguards that would apply to contracted workers. And then we come to the supply chain. What are the rights with regard to supply chain? Next slide, please. With regard to the supply chain, you will find that the safeguard says that you cannot have child labor in your supply chain. You cannot have forced labor in your supply chain. Your supply chain must be safe. Occupational health and safety. Sorry, that should read as life-threatening situations, particularly with regard to life-threatening situations, there needs to be proper occupational health and safety. So if you're operating a mine, for example, mine workers, life-threatening situations in the mine, these things need to be taken care of through proper health and safety provisions. And then if remedy is not possible, that is to say, if you find that there's child labor, forced labor, or improper occupational health and safety conditions, and you cannot get the supplier to change those, improve them, remedy them, then the safeguard says you need to consider shifting to other suppliers who are complying with this standard. Now, we may not all agree with that because cutting and running from a supplier who is indulging in forced labor may not be the right remedy, but that is indeed what is in the safeguard at the moment. So in that respect, perhaps that safeguard needs to be improved a little bit and reformed. But with that, I hope that gives you a framing for our next set of presentations for this webinar. Thank you.
Thank you, Lalanath. I think that framing really helped us, especially understand the existing conventions in place, some of the indicators around forced labor, which I think for me, seeing that list, it's interesting to see how many of those forced labor indicators are very much intertwined and interconnected, especially with, as you mentioned, removing the documentation that someone has really puts them in an extremely vulnerable position once they're in a country. And obviously, in terms of their ability to, complain against their employer, it puts them in a very precarious situation. If they don't have their passport, they have little power in terms of the situation. So I think that really helped us with understanding where this is all stemming from. I think on the GRAM side, it's good that you kind of were able to highlight the different layers and levels of how the IFC safeguard standards apply. And it seemed quite extensive in terms of the different levels of the chain of work that you would see within a development scenario. So thank you for that introduction. I think now we will pass it on to our colleagues over at Transparentum. I think Jonathan Mead will start, and then he will pass it over to Andrew. And as mentioned before, they'll talk about worker rights in ILO conventions, investigations into worker rights abuses, and some company engagement. So I'll pass it over to you, Jonathan and Andrew.
Thank you so much, Peter. Good afternoon, good morning, good evening to everyone, wherever you are. I'm Jonathan Mead. I'm Transparentum's Director of Investigations, and the purpose of our presentation today is to introduce you to Transparentum, our work, and provide some context to issues related to grievance redress mechanisms that we've seen in our investigations and in our work with companies to catalyze remedy for affected workers and communities. So we can dive right in if we can jump to the next slide. So our mission at Transparentum is we're an investigative unit, a small nonprofit that seeks to advance the well-being of workers and communities by working to eradicate environmental and human rights abuses in global supply chains by exposing hard truths to those with the power to transform industries. And we can go to the next slide. So we work to achieve our mission by conducting investigations into supply chains, so far primarily in garment producing countries in South and Southeast Asia, though we're excited to now be expanding to other geographies and new industries. Our investigations speak directly to workers and communities about labor rights and environmental issues they are facing, and carefully gather evidence to document conditions on the ground. We then craft reports from the results of our investigations that we deliver directly to international companies that are sourcing from the investigated factories, farms, forests, or mines. These reports detail the abuses we've documented, along with recommendations for how to make improvements at the immediate work site and community level, as well as to make broader policy changes across their supply chains and work together with other companies for industry-wide improvements. After giving brands a discrete window of time, usually a few months, to implement these remedies, we then disclose both our original findings and the successes or failures of the brands in implementing solutions to regulators, their investors, the media, peer civil society organizations, and other stakeholders to continue to drive accountability. And we then also closely monitor the situation on the ground and issue further reports and complete advocacy work as needed to ensure remedy. And we can jump to the next slide. The focus of our conversation today is grievance mechanisms, but before I turn it over to my colleague Andrew to explain more about what we have found on this topic, we also wanted to provide a snapshot of all of our disclosed work to date. As you can see, we have completed investigations in Bangladesh, India, Indonesia, Malaysia, and Myanmar. Those who are interested in our other projects can find summaries on our website for each. We have focused primarily on tier 1 factories responsible for final assembly, but have also focused investigations at tanneries, spinning mills, and other lower tier work sites. And of course, we know issues including lack of effective grievance mechanisms are often amplified the further along the supply chain we get from companies' direct leverage. And beyond the publicly disclosed projects you see on the screen, we have several ongoing investigations at earlier stages of our project lifecycle that we're excited to disclose soon. And I'll now hand things over to my colleague, Andrew.
Great, thank you, Jonathan. So as Jonathan noted, our investigations begin with what workers are telling us about the conditions that they are facing. And this often includes reports that the mechanisms available to them to raise grievances within their workplaces are insufficient. So what you see on the slide are quotes from workers from a recent investigation into conditions for garment workers in Malaysia, which I will read out to focus on these workers' experiences. So for example, to the left of the screen, you see, nobody listens to our complaints. When we tell the company about poor conditions, they start scolding us, and that is why we don't. In the middle of the slide, we go to the office and tell them about workplace problems, but there is no response. And that quote actually goes beyond what appears on the slide. This worker went on to say, whenever we tell them, the company, anything, they say, go back to your home country. And that's aligned with workers' experiences from a different factory. In the third quote, if someone complains, they say they will send us home. So as you can see from the quotes, workers often fear retaliation in their workplaces for raising grievances. A lot of our work at Transparentum centers around protection of migrant workers, and we hear often that workers can be threatened with deportation for speaking out about any conditions that they find unacceptable in their workplace. And these findings, of course, are not found in isolation. Our projects center around serious endemic issues, such as the indicators of forced labor that Lalanath was describing earlier, or child labor, or other issues like that. And what we often find is that those serious issues then are exacerbated by workers' inability to take action to fix workplace problems by themselves. Migrant workers like those we just quoted experience exploitation during the recruitment process. They're promised jobs and working conditions that don't match the reality that they face when they arrive in their destination country. And then they find their ability to seek redress for the reality that they do find is compromised when the grievance mechanisms available to them don't work. We find in some cases they don't exist at all, or that workers don't know about them, or that workers do know about them but find them ineffective, or are afraid to use them, as we noted from the quotes on this slide. So moving on to the next slide, once we find issues in supply chains, we go to companies directly with the findings of our investigations. And we wanted to give you sort of a snapshot of some responses that we got on this investigation in Malaysia. And as you can see, we've gotten some mixed responses. Sometimes companies will want to deny responsibility outright. Other times, companies will take a more guarded approach to our findings, but will willingly engage nonetheless in order to try to protect workers or protect their reputation as a company. Other companies we have found more eager to dive in, recognizing the problems that we have raised from their own human rights due diligence programs, that we're finding issues that they have found previously and that continue to need improvement. We also see a range of sophistication amongst the companies that we approach as to what an effective human rights due diligence program really looks like. This ranges from companies that we approach that don't even have a code of conduct in place covering those sorts of issues that Lalanath was speaking about earlier, to others that have a very high functioning social responsibility department, but with gaps where we have found issues in those gaps. Many companies already appreciate the role of grievance mechanisms in their human rights due diligence program, and how the need to provide these tools to workers provides a win for everyone, with workers empowered to participate in workplace improvements more directly, and risks in companies' supply chains more easily mitigated by workers being empowered to take these actions on their own. That being said, as I mentioned at the top of this slide, we found a very mixed picture regarding company effectiveness in responding to our grievance findings and attempting to improve those mechanisms for workers. So what you see on this slide are similar findings on an investigation where, for example, at Factory A, while the buyer we spoke to claimed that the factory had an anonymous grievance channel in place, workers didn't know about it or were afraid to use it and ultimately experienced no change over the course of our engagement with companies. By contrast, looking at the bottom of this chart, at Factory C, the buyers that we engaged brought in a third-party assessor who not only corroborated what workers told us about the factory being non-responsive to workers' complaints, but through a policy review with the factory itself, found that the grievance mechanism that was in place didn't include a policy guaranteeing workers' protection from reprisals. And therefore, through all of this collaboration between the companies, the brands and their third-party service provider, they required the factory to update the policy to train workers, crucially, on how to use the procedure. And then that third-party assessor corroborated that these improvements had been made. So Factory C represented more of what we're looking for through our engagement with companies. And then Factory B was sort of the middle way, sort of a Goldilocks split between these three factories here, where at Factory B, the finding was corroborated that there was a lack of a viable anonymous grievance channel in place. But when we followed up with workers, some said it was working and that management was newly responsive to complaints, while others said, no, management is not responsive. They're only responsive to complaints about living conditions in the hostel, but not to any workplace complaints. So that's just a snapshot of what company responses look like when we go to them with a grievance finding alongside our other findings related to forced and child labor. And then finally, what do we tell companies when we have a finding related to grievance mechanisms in the workplaces in their supply chains? Well, we start with what you see on the screen, with internationally recognized standards around what a grievance mechanism should be. So according to the UN guiding principles, a grievance mechanism should be legitimate, accessible, predictable, equitable, transparent, rights compatible, and a source of continuous learning based on engagement and dialogue. We try to put these characteristics into plain language for companies and provide them examples of what we think these criteria mean in practice in the context of a given investigation. So for example, in our investigations involving migrant workers, to make grievance mechanisms accessible, as the UN guiding principles call for, we point out that they need to be available in the native languages of all the workers in the facility. And workers could be coming from many different countries. So this might mean a great deal of translation to make sure that every worker in a facility understands their rights and their abilities to file grievances. This also improves their legitimacy, is compatible with workers' rights, and can help lead to continuous learning between the worker and the company. We also point out that there should be more than one mechanism in place, and that at least one mechanism should be anonymous, and at least one should be administered by a third-party worker-focused union or NGO, apart from the companies themselves if workers feel uncomfortable reaching out directly to a supervisor or even to a brand. We also point out that workers should be provided with a description of all of the available processes, possible outcomes, and what the timeframes look like for providing remedy to grievances. That workers should be provided with status updates on outstanding complaints on a regular basis, that measures to prevent retaliation should be disclosed clearly to workers, and that all outcomes and remedies should be in accord with human rights standards. Regarding training workers in languages that they understand, we urge buyers to insist that suppliers post these grievance channels throughout workplaces and dormitories in workers' native languages, and provide rights training to workers so that they're aware of the treatment that they can expect at work. We know that workers who are aware of their rights are more informed and able to file grievances, and that effective high-functioning grievance mechanisms can make our work as an NGO less necessary, as more and more highly involved workers are able to seek and achieve their own workplace improvements through effective dialogue with management, or via worker advocate channels who may also be managing a grievance mechanism. And I think with that, we turn it over to Radhika and some of the Accountability Council's experiences, and then we'll also be able to answer questions about Transparendum's work at the end. So over to Radhika.
Yes, thank you. First, I just wanted to thank you, Jonathan and Andrew, for sharing the work that Transparendum is doing in investigating supply chains, and especially in making the link, I think, between the workers and these larger companies, and bringing to their attention some of these very serious labor issues. And I think, as you highlighted, it's quite interesting to see the range of responses that you get from companies based off of your findings. And I think maybe, yeah, we might have some questions on that a little later. But with that, yes, let's move on to Radhika, who will talk about some of the work that Accountability Council is working on. So over to you, Radhika.
Hello, everyone. Thank you so much, Peter. Am I audible? Yeah, my name is Rahul, and I work with Accountability Council. It is a nonprofit organization that partners with communities who have been harmed by international finance and are seeking redress. We have advised over 50 communities on their cases before accountability mechanisms, and we use these lessons from our cases to advise banks on how to best design effective mechanisms. Thank you so much for this opportunity today and for organizing this very important webinar. I also want to thank my previous speakers for those very insightful presentation. Starting on, could we go to the next slide? So building off on what we've already heard about types of labor harms and the process of investigating and engaging with companies, I will be talking about what we can learn from these labor-related complaints as they come before international accountability mechanisms, or IAMs. So the key takeaways actually echo exactly what Andrea has already laid out for us, which is that anyone handling these cases or designing mechanisms must expect labor-related complaints at all times. And there are risks of inadequate labor standards in all types of investments. Further, international financial institutions must be prepared to remedy labor issues and exercise leverage over clients to do so as well. I will primarily be using research from the Accountability Console, that is a database of all known mechanism complaints, and I will share a link to that on the chat later. As of today, that number stands at 1,802 complaints, and I will also supplement that research with a case study. Could we go to the next slide? So based on the research, I have shared a few facts on the screen. So 5.2% of all cases have labor issues. Now, this is a modest and yet significant number, and it tells us that mechanisms must be prepared to come across cases with labor issues. I would also guess that this is a conservative estimate, as we can understand, and we've already heard that there are obvious risks for workers to allege non-compliance against the very people who are responsible for their livelihoods. So it is important, first and foremost, that IAM should be accessible, should encourage workers to raise issues, and commit to protecting them from retaliation. Now, cases have come from various projects. And as you can see on this list on the slide, there are obviously many labor-intensive sectors. But however, cases have come from many industries, especially we've seen cases in projects that are labeled green or climate friendly, or for example, even projects that are to do with regulatory development. So for example, in a project for providing national identification cards to Malawi citizens, we saw that a complaint was filed by registration officers who said that there was not adequate labor safeguards. Interestingly, a high number of cases have been found eligible at 83%, which compared to the rest is general eligibility rate is only 38%. We've also seen that cases that have raised labor issues have also raised these other important issues, including retaliation, which we've already discussed. Cases have gone to both dispute resolution and compliance review. And this is important because mechanisms, whether new or existing, must have both, because one or the other is not always sufficient and does not do what is required. In terms of timeline of the eligible complaints before IAMs, cases have taken anywhere between 4 months to 5 years, with most cases being between 10 to 20 months. So for labor complaints where livelihoods are on hold, such a delay can cause continued harms, and mechanism should establish timelines for each step of the process and strictly adhere to those timelines. Can we go to the next slide? Overall, the complaints tell us that due to inadequate environmental and social due diligence, a lack of human rights due diligence and supervision, international financial institutions often fail to identify the risks that project creates for its laborers. Even when safeguards are adequately identified, a lack of monitoring and implementation, a lack of inadequate project-level grievance mechanisms, which is also something we see across our clients, a lack of monitoring and implementation means that workers face serious issues. And I've listed some of these issues on this screen here, and I will discuss this using a case study with the next slide. So we saw many of these issues in a project by Buchanan Renewables in Liberia. It's a biomass project that failed due to poor project design, including an inability to identify vulnerable communities and their needs, and therefore a failure to protect them. So the case was where Overseas Private Investment Corporation, which is now the US Development Finance Corporation, had invested in a project that aimed to support the creation of a sustainable fuel for use in Liberia. So the project was that they would harvest unproductive rubber trees and convert them into a biofuel in the form of wood chips. The project failed, and Buchanan Renewables abruptly withdrew from the project area in about early 2013, devastating local communities, many of whose rubber farms had already been destroyed. In their wake, the project left multiple groups of stakeholders worse off, but this included many workers who suffered from rampant labor rights violation. So there was a systematic failure to provide workers with adequate protective equipment and safety training, which exposed them to life-threatening working conditions. So we saw workers who suffered debilitating and permanent injuries, including being trapped under fallen trees, having their limbs broken, and did not receive adequate care or compensation. We saw some workers who were doing full-time jobs and were called unpaid volunteers for up to 2 years. Several female workers reported that their male supervisors had sexually abused them and retaliated if they refused their advances. There was also a failure to provide adequate drinking water to the majority of its staff, discrimination between foreign or expat workers and national workers, and instances of verbal, physical abuse against workers. So in 2013, after months of supporting local communities as they attempted to contact these international institutional investors through unofficial channels, we finally produced a video and a detailed report that was then filed with the OPIC's president, who then directed the Office of Accountability to investigate. And so it was a very long journey to actually start this process. What the investigation report, once it came out, confirmed was that workers had suffered from severe harms, and it recommended putting in place more robust screening, risk mitigation, monitoring systems, and implementing human rights due diligence, which we've seen as our common recommendations. However, for the people that suffered from the harm, that bought the case, the workers, the other stakeholders, that actually contributed to the institutional learnings, we saw that there was no remedy, and the financial institution refused to discuss any possibility of remedy for them. And even a year later, a monitoring report revealed that institutional policies had not been adequately updated in response to the report. Can we go to the next slide? So in terms of lessons from the case, there are obviously many lessons to be learned, but for today, I'll be focusing on the most important ones. Firstly, I think the process of getting accountability from IFIs is never easy. All impacted communities, including workers, take a lot of personal risk, resources, and time to engage in the process. And IFIs should increase both its own support in terms of financial costs, which is good practice, covering financial costs in accountability mechanism policies for the complainants, for simplifying processes of filing a complaint, and finally, removing any restrictions for representatives, whether local, national, or international, because this kind of support is absolutely essential. Secondly, before a complaint was filed, efforts were made to engage with managers, supervisors, set up a project-level grievance redressal mechanism, and engage informally with the IFI. And only after all of those things were done was a complaint filed. But who communities choose to raise an issue with, when, and even if they actually choose to raise an issue, should be best left to communities themselves, who are experts in identifying their own reprisal or retaliation considerations. And they should not be asked to exercise faith in bodies that are not independent. And while I'm not saying that this means that project level grievance mechanism shouldn't be strengthened, what I believe is that IFI should acknowledge and not mandate prior engagement with another body before accessing the IAM. And certainly, as we've seen across some policies, not require specific engagement with any one particular sub-institution within the IFI. Third, we saw that the IAM process did not result in any remedy for individual workers. This is the unfortunate reality for a lot of cases. And the truth is that remedy is rare through this process. IFIs must be more remedy focused in their approach to cases, both for dispute resolution and for compliance review. So this means must mandate the creation of remedial action plans, allow communities and IAMs to comment and strengthen these plans, and finally promote strong monitoring of these plans. There is also a need to strengthen provisions for prevention of and protection from retaliation. And this should be both for the safeguards policy side and the AM side. Now, could we go to the next slide? With those lessons in mind, I will spend a few minutes just sharing some initial thoughts on what remedy has looked like in some labor cases. This is part of our ongoing research where we have compiled a list of all commitments towards employees arising out of every known IAM case. And this includes cases with labor issues. So in total, there are 62 commitments across 33 cases, and because multiple commitments can come out of one case, of course. So we've divided this into three things: employee trainings, employee conditions, and employee opportunities. These commitments are a fascinating insight into what type of solutions IAMs have proposed and what they haven't proposed so far. So employee trainings include training bank staff or clients on the bank's environmental and social policies, or how to conduct meaningful consultation, how to better design project level grievance mechanisms, because those failures have been highlighted. But in one case where they found that the client had failed to abide by performance standards on labor relations with IFC, there was a requirement to train workers and management on how to address workplace issues. Employee conditions include increased monitoring of client performance on specific safeguard issues, whether health and safety or at the floor, lack of unpaid overtime work. But it could also include like a stipulation to provide personal protective equipment and maintain health and medical facilities. Finally, employment opportunities include giving preference to local workers, hiring one worker from each family, giving specialized jobs for locals. And in one very interesting commitment, they supported self-sustaining business development for former employees by giving them contracts to provide uniforms and then also supporting their initial operating costs. So these are some really interesting commitments that have come from the IAM processes. What is missing and what we saw was that commitments towards female workers were not as common or even present. So commitments within labor conditions in ongoing projects have not included specific improvements for female workers. And this could be because the data has not been disclosed or because the data doesn't really exist. And can we go to the next slide? The other thing is that in terms of implementation, because that was the commitments as it exists on paper, but in terms of implementation, out of 62 commitments made across these three sections, only 20 have been accomplished. So that's less than half, and 6 are in progress, while the remaining 36, we don't have any information available at all. So like a continued lesson has been that improving information disclosure is absolutely must for like anybody even doing research or actually following and monitoring this case. We also see that when it comes to getting effective remedies from IAMs, a lot needs to be improved. To conclude, while there is good practice to be learned from labor cases before IAMs, overall, we see that the system isn't working as well as it could. And those of you designing mechanisms can learn and iterate to be sure that the accountability channel is effective for workers. That's all. Thank you.